Okay, so legal challenges for entrepreneurial ventures. So one of the things that you could be doing is to say, if you've got an invention, not only do you have a new business, but you actually have an idea or a design that you want to patent. So what happens is you can actually apply, if you've got an invention that you've created and you want to protect this invention from anybody stealing or anybody copying this invention, then you can apply for a patent. And the patent office here in Australia is IP Australia. You can actually go to this website, and from there, read what the requirements are to apply for a patent. When you apply for a patent, it's not automatically given to you. The office will actually review your application, but it's good idea to apply for that patent. And while waiting, then at least people know that you have already a patent that's been pending. That's why sometimes some companies put down patent pending, which means that you have already applied for a patent and you're waiting for approval from the IP office. When you are granted a patent, then this provides the owner the exclusive right to hold, transfer, and license the production and sale of the product or process as an intellectual property right. Once you are granted a patent, this patent will last for 14 years generally, and sometimes it can go up to 20 years depending on the kind of patent you're applying for. I think for pharmaceutical patents, for example, I think that's higher. So intellectual property rights usually result from a unique discovery of some sort. So patents are reserved for tangible objects. You cannot patent an idea. If it's just in your head and there's nothing, you've not written anything down, you cannot patent it. However, if you make a design, you may not have manufactured the product yet, but you have a design on paper, and you describe your design on paper, then this can be patented. So items that qualify for patent protection include processes, machines, products, plants, compositions of elements, and improvements on already existing items. All right. Does anybody know the difference between a patent and a copyright? Anyone?
So I think copyright can't be copied, and if you're using somebody else's patent, you need to pay a certain royalty on the thing you're doing.
All right, so a little bit of confusion there. A patent and a copyright, they're not the same. If you're the copyright owner, well, first of all, copyrights are applied to artistic work and creative work. They don't necessarily apply to tangible objects the same way patent does. So for example, if you're writing a book, then when you publish that book, that becomes your copyright. You own the copyright to this book. But if you invent a machine, then that is a patent. It's not a copyright. It's a tangible object that you have created, or a design of a tangible object. Okay, so copyrights apply to things like literary or artistic productions. For example, if I'm creating a PowerPoint slide like this one, and I decide to copyright it, or once I've written it down, I'm actually have created an automatic copyright. And none of you, or no other person can actually reuse this slide unless there are certain conditions to it, right? Unless I give permission, for example. By the way, these slides are created by Cengage. So on the lower part, you'll see Cengage Learning may not be scanned, copied, or duplicated, or posted in a public accessible website in whole or in part. But because we are using the Cengage book, we've actually asked permission from Cengage, and Cengage gives us the permission to be presenting these slides to you people, to you students. If I'm the owner of the copyright, I can also grant permission to a person, like a school, to copy my work because I've granted them permission to do so. So generally, the duration of a copyright is the life of the author plus 70 years. So generally, if a person lives to 100 and plus and dies when he's 100 or she's 100, then 70 years after, then you can copy and republish a piece of work over and over again. Okay, so roughly 170 years after the creation of the work, or actually less, because if you've created the work, let's say if you were 99 years old and you wrote a book and then you died a year later, then it's basically 70 years plus 1 year, so it's about 71 years. So copyright owner has the rights to reproduce the work, prepare other works based on it, distribute copies of the work, perform the work publicly. So if I might be creating a movie, so I produce and create a movie, I film it, that becomes my copyright. I mean, I own the copyright to the movie, and I can show the movie as much as I want, but other people cannot copy the movie and show it on their own. So that's the basis of basically if you're stealing somebody's movie or downloading a movie from the internet, technically you are violating the copyright of the movie owner or the producer. Any questions so far on the difference between a copyright and a patent?
No.
Okay, so if I suddenly invented a drug, a medicine that cures COVID-19, what would I do? Would I apply for a copyright or should I apply for a patent?
A patent, sir.
A patent, correct, because it's a tangible object. Oh, by the way, it doesn't have to be the actual medicine. I can apply for a patent just based on its chemical composition. So if I create a document that describes how to make this medicine, then I can apply for a patent. However, it doesn't mean that if I apply for a patent, it means it will be approved. It takes a number of years before approval is given. Okay. Now, if I'm that's a good idea. If I'm painting something, or maybe I take a picture. This is a better idea. I take a picture using my phone camera. I take a picture of a person. Do I have copyright of that picture? So can I basically copy the picture, or can I give this picture to someone and that person? Does that person have the right to republish my photo?
You taking it as a like magazine, or you just taking? Did you ask for permission?
No, I took the picture myself, and I basically
yourself. Oh, yeah.
I take a picture of, say, I take a picture of Warnon, and then I decide, okay, it's my picture. This assumes, of course, that I've asked permission from Warnon to take her picture. So I take a picture of Warnon. She says, "Yeah, go ahead, take my picture." Technically, I should ask permission before I publish it, right?
Yeah.
From Warnon. But does Warnon have the right to copy that picture? Suppose she gets the picture from me. Does she have the right to make money from it and sell this picture to other people? It's a picture of her. It's her picture. I mean, it's a picture of her. It's not her picture. It's a picture of her. But does she have the copyright?
No, because it's your.
That's right. It's the photographer's work, and therefore the copyright belongs to the photographer. Okay.
Doesn't the photographer needs permission?
What do you mean? Does Warnon need permission? What do you mean by that?
The photographer.
Oh, yes. Assuming I ask permission from Warnon, I said that. So if I ask permission from Warnon, I take a picture of her and she says, okay,
No,
then
I mean to use it for a business purpose, like maybe advertising her photo.
yeah, absolutely. That's what I meant by asking permission. Can I take a picture of you? And that usually means that I can use it for whatever purposes I want. Warnon could say, yes, you can take a picture of me, but you are not allowed to give this to any magazine or to any commercial, use it for any commercial purpose. And therefore, I cannot sell it. I cannot give it away to anyone, especially if it's for a commercial reason. But if I take a picture of anyone and it's not recognizable as that person, that's my copyright, especially if nobody is identified in the photo, and I can actually use it for commercial purposes.
What about if, like, you're a photographer and you take a video of one little girl and then you put it on advertise for this year and you pay money, right? And next year you report this advertise again, you have to pay her money again. What's that called? Is that copyright or not?
That's a talent contract. So if I have a contract with say a person and I say, can I take a picture of you with the understanding that I'll use this photo or video for commercial purposes? And if there's no time limit, I mean, it really depends on the contract. If the contract is for 5 years, then you can use it for 5 years. Most talent contracts actually are renewable every year or thereabouts. The problem is if it's silent and there is no description of the time limit, then I don't know. My dog is here. Come on. All right. So if there's no time limit to a contract, then it's gray area. But I think it'll be, if there's no time limit, then you cannot automatically say that it's every year. So the talent does not have any right to sort of say, look, I gave you permission, but it's only for a year, but it's not written down in a contract. Therefore, the photographer can keep using that photo over and over again. Okay. Now, one thing about copyright, and I think it's mentioned here, or it's not mentioned here. The material must be in tangible form so it can be communicated or reproduced. So a tangible form would include digital. So if I take a digital photo, that's considered as a tangible form. But I cannot say I have a book. I've written a book, and somebody says, "Where's the book?" It's in here. That's not a tangible form. I mean, a person could have invented something in his head in terms of a story or an idea. But if that idea was not stored in a tangible form or in a written form, then you can't claim copyright. Okay? The other thing about copyright is it also must be the author's own work and thus the product of his or her skill or judgment. So I can't, I cannot grab Wirenon's work, for example, and then add a few words and say it's my work. That's technically not fully my work. I need to get permission from Wirenon, number one. And arguably, there could be an agreement where the copyright is actually both Wirenon's and my copyright. So we may have an agreement where she can, what they call this, use the work on her own, and also myself. I'm sure you've seen a lot of this in the music world. You know, when a music artist samples another artist. Have you heard of that? It's called sampling. You know, like a rapper. A rapper will take a song and then add his lyrics to it and add his own interpretation of that original song. Are you with us, Cyril? Cyril would probably know this. Are you musical, Cyril?
A little bit, maybe.
Can you think of a song that's been taken by an artist from another song and added his own lyrics to it or his own rap to it?
Yeah, there's a lot of artists, most especially, for example, if the music came out in the 80s or 90s, and then they just use that music and then add their own rap, which is their own intellectual property in a way, to it, then yeah. So that's a typical example.
So
There's heaps
you're
of
absolutely right. Now, what's happening there though is that's a bit complicated because what has happened is you are now you're claiming copyright over something that's partly your copyright.
Yep.
Okay, so usually what happens is before I even copy or before I even start using portions of your song, I need to ask permission. And usually there's a bit of a royalty payment involved. So if I want to use Taylor Swift's music and add a little bit of my own into it, I need to actually ask permission from her management if I can use this. And her management will probably say, yes, but you need to pay me an amount of that royalty because you are sampling my music. The other thing that's important is while in the US, there is a copyright office, the Library of Congress. Here in Australia, there is no formal copyright registration. So they say that as soon as you put something into paper, or if you type it out, you've created that work, you place it somewhere in a digital form, that's already automatically you've created a copyright to it. Of course, the difficulty will be defending that copyright. So somebody can easily steal that from you in one way or another, and it'll be very difficult for you to prove when you actually wrote that versus when that person used that copyright. So, for example, by some stroke of luck, I composed some music, and it's very, very similar to another artist's music, then that other artist could be suing me. But if I can prove that I made the music before he made the music, then he has no grounds to be suing me. Clear? I'm not a lawyer, by the way. Yeah, so just basically these are just basic knowledge of law. Are you guys still with me?
Yes, sir.
Okay,
Yes.
so other
Yep.
things with regards to copyright, there is such a thing called fair use doctrine. So fair use doctrine means reproduction of a copyright work for purposes such as criticism, comment, news reporting, teaching, study, and research is not an infringement of copyright. So I'll give you an example. So here you've got a set of slides that I'm showing you. The copyright is owned by Cengage Learning because they put these slides together. What if you decide to print out these slides? You download the slides from Moodle, you print it out. Maybe you might print one copy and then you give another copy to your friend. Are you violating the copyright of Cengage?
Maybe.
Try to give me a definitive yes or no.
So
Don't
no
worry,
violating.
it won't affect your grade. Amir.
Sir, if I give to another person who doesn't, who doesn't belong to the college, then it might be a violating. But if someone is steady and I'm a friend and we are both studying same college, so if I can give him, though I don't think so it's any problem.
Ah, very good answer, Amir. You must be a lawyer. You're right. So if I were to copy for my use and I am a student, for example, then I can argue, well, I'm doing it for research and for study purposes, and I'm allowed to do that. But if I were to give it to a friend, and let's say again the friend is not a student, then that would be an infringement because that person, I'm not really supposed to be giving that to another person. I can use it for myself as a student, but if that person is not a student, then we can argue that that's an infringement. Okay, so Copyright Act specifically excludes copyright protection of an idea, a procedure, a process, a system, etc. Regardless of the form for which it's described, explained, illustrated, or embodied. So in other words, you cannot copyright an idea. You can patent a process, but you cannot copyright a process. Okay, unless I think if you've written it down and published it, then that would be, you could claim that that could be a copyright. Okay, so we've talked about patents, we've talked about copyright. What are trademarks? Before I go on, does anybody have an idea what a trademark is?
Trademarks are like a monogram or something like a specific for a company.
Correct. It could be a symbol, could be a set of words that you are using for trade. That's why it's a trademark. So when I say trade, it means for business purposes. It's a name, a mark, a symbol, a motto. So it could be a slogan. And you're identifying it as part of your company's product. Then you can actually register it in IP Australia. So there are advantages to that. If you've registered that trademark, immediately there's a timestamp on when you registered it. So if somebody comes up with a very similar symbol or name or motto, but you've already trademarked it ahead of time, if you've already applied for it before he did, then you can actually sue that person and prevent that person from using that trademark which you have already previously registered. So it affords you some protection as well against importers using that same mark. And if you're exporting your product abroad, then it gives you a little bit of protection as well because you can use this as basis for suing a foreign company. But the best case really is, in many cases, you must register a trademark in every country that you actually operate in. So if I'm exporting something to China, it would be good for me to actually register that trademark in the Chinese IP office as well. Generally, when you register something, that mark will cannot be basically it can be defend you for 5 years, and then after that, I think you can reapply. But again, it's something when you apply for it, it's not automatically granted. There is a time period in which the office will decide whether this trademark is in fact defensible or not. Okay, some tips when you're trying to apply for a trademark. Never select a corporate name or a mark without first doing a trademark search. So, you know, if you come up with a name and then you register it, you pay money and all of that, it can cost you a bit of money. And then later on, the office will tell you, we're rejecting it. And the reason why is because that trademark already exists. So you've wasted your money. So again, you can easily do a search. In fact, I can show you how to do that search. I hope. Just type in on Google IP Australia. And there it is. So you can search for trademarks. All right. Now, suppose I'm doing a new company and I decide, I think I'm going to register the name BD. So BEE DEE. Oh, maybe I should search for it. I don't know if this will work, but anyway. Okay, oop, trademarks. There's the search trademarks. Sorry. So here, search for trademarks. So the company name, suppose, or product name, by the way, product or company. So if I say BD, I find there are 12 results. So unfortunately, somebody else is using my my proposed trade name. And I can actually find out who these people are. And you can see that BD Bags has already registered that term BD. It's registered, and it's not just registered, it's protected. So they have granted protection, the IP office. Okay, so you can see all of these search terms that reflect BD. The word BD is registered, and separately the logo is registered as well. So if I click on that, you will see the logo has also. So it's a symbol, and also the phrase is copyrighted. You'll see here it was filed in 2014, accepted, advertised. So in other words, I think you're supposed to advertise and saying, does anybody else own BD or using BD in their own business? And then it's registered, entered on register, a few months after, so accepted by the office. And the registration has also been advertised by the office itself. So this is in place until 2024 renewal. So you need to pay the office again once you renew that logo. The frustrating part is this is just Australia. If you were to use this brand name and went to the US, then oftentimes it doesn't follow. You need to register in the US as well. I'm not sure if there's a treaty between the US and Australia, but if there is a treaty, sometimes they have an agreement that the trademarks of the US cannot be used in Australia, or the trademarks in Australia cannot be used in the US. Unfortunately, I don't know yet at this point. Rule number 2, if your attorney says you have a problem, please trust the judgment of your lawyer. Third rule, seek a coined or a fanciful name or mark before you settle for a descriptive or a highly suggestive name. What does this mean? This means that you shouldn't try to register a trademark that, say, if I'm selling bags and I decide blue bags. Blue bags is very descriptive. It is actually an existing word, the color blue, and bags is also an existing word. So if I go around saying my company and my product's name is Blue Bags, most likely the trademark office might reject it because it's too similar to an existing word. However, if you were to use like BD bags, BD is, there's no meaning to that word BD. Another example is Google. Google is a registered trademark, but it doesn't really mean anything. That's why it's so easy to be trademarked if somebody comes up with a word like that. Kodak is also a made-up word. What else? So, lots of these words. Uber. Uber is not really a word. But it's been trademarked, and we all know what it means at this point, right? What are the other food delivery? Foodora or something like that, or yeah, business names. You'll see that they're choosing these names because they can trademark these names because they don't mean anything to anybody else and nobody else can claim them. Did you get what I mean by a fanciful name?
Yes.
I'll take that as a yes.
Yeah.
Rule number 4, whenever marketing or other considerations dictate the use of a name or a mark that is highly suggestive of the product, select a distinctive logo type. So let's say I want to register the word beer. A beer, of course, you know, it's a drink. It's very descriptive of the drink. I may not be able to register the name beer, but if I put a logo in there, then I can register the logo, the symbol. And if the symbol is unique, and it can be seen as an acceptable trademark. So last rule, try to avoid abbreviations and acronyms whenever possible, because again, it'd be very difficult to trademark it. It might be rejected by the office. Okay, so I think this is the last term. We talked about patents, we talked about copyrights, we talked about trademarks, and this one is trade secrets. Business processes and information that cannot be patented, copyrighted, or trademarked, but makes an individual company unique and has value to a competitor could be a trade secret. So examples of these are your list of customers. You develop this list, you had a relationship with them. That's actually very valuable. If your competitor steals that from you, that competitor can actually steal your business away from you, right? So that's an example of a trade secret. Whatever research and development you've done for your business, it could be a secret, but then, or your strategic plans as well, could be a trade secret. You don't want to share your plans with your competitors, etc., etc. So that's just all examples of trade secrets. The question now is, can you protect yourself? If you have a trade secret, is there an IP office that you can register your trade secret in? Anyone?
A trade secret as in?
I'm sorry, Sadman? Sadman, what did you say?
Yeah, sorry. What does a trade secret mean?
It's right in front of you. You should be reading it.
Okay.
A trade secret, again, is something that makes a company unique and has value to a competitor. So
Yeah,
it's something that you want to keep to yourself. It's a secret, and it's part of your... I'll give you an example of a trade secret. If I have a recipe for a very good chicken curry dish, I don't want to share that with anyone because I sell that in my store, and I don't want to share it with anyone. Can I register that?
I think so.
No, you can't.
No.
You can?
You cannot. You cannot. It says here, trade secrets cannot be patented, copyrighted, or trademarked.
So you just have to keep the secrets.
So the problem with the trade secret, you need to protect it yourself, number one. There is no statutory protection in Australia. In other words, you cannot use the law to try to protect. If somebody steals that, it's very difficult to prove that you basically, that's my secret. You know, you cannot prove that. You cannot register it in any body. However, what some companies do is they create NDAs. An NDA is a non-disclosure agreement. So if you have an employee and the employee is dealing with your trade secret, maybe your salesperson, you want to prevent that salesperson from stealing your customer list. Let me just again mute everybody, because it seems to be a little bit of a all right. So if you want to prevent your employees from stealing your trade secrets and sharing it with your competitor, then you must have an agreement with that employee that he or she is not supposed to be grabbing that information and sharing it with a competitor, even after that person is resigned from your employment. Okay. So the non-disclosure agreement is a contract. And if he violates that contract and you have evidence that he is in fact violated it, then you can sue and use your contract as basis for suing your employee who has shared your trade secret. Okay, this is a good topic. This is if you're going to establish your business, what kind of an entity can you create here in Australia? So I just researched this today, and it's slightly different from the US. So that's why I use Australia as, business.gov.au as my resource. There is such a thing as a sole trader, or if you want to do a partnership with someone, or you want to create a company or a trust, and we'll go to each one. Okay, sole trader, a business that is owned and operated by one person. Very simple to set up, very easy. The registration fees are quite low. And anyone can become a sole trader basically with very little. All you need, I think, is a tax account number or tax identification number. The
ABN
problem,
as well.
sorry, ABN, yeah. Yeah. So once you do that, you've established your business. But remember that if you're the sole trader, you are legally responsible for any debts and losses to your organization. So if, let's say, you do business and you borrowed some money, not borrowed money, but let's say, borrowed money from the bank, then your business folds up, the bank will go after you and your collateral. Okay? So you can't say, oh, my business folded up, but that's my business. I'm not part of that business anymore. Or, you can't sort of hide behind the entity, because what happens is you are part of that business. If, let's say, you have a supplier and you buy something from your supplier and you don't pay your supplier, the supplier can chase after you, not just your company, but your own assets, your house, for example, okay, the house that you live in. Okay, so some advantages and disadvantages, as indicated here. Very flexible, no need for a separate bank account, although they say it's probably best that you separate your bank account so it's easier for you to account for what's happening in your business. But again, you have unlimited liability, which means that if you have a liability like a loan or you owe someone, then that person or entity can run after everything, even the shirt off your back. Okay, you cannot claim that it's my business expense. Lack of continuity, less available capital. In other words, the capital that you're using should come from your own pocket. You cannot, get an investor or something like that, or you cannot also. It's also harder to get long-term financing. So what happens is the bank will probably lend you money, but they will say, well, you need to have a collateral, your house, or a property, or a car, or whatever assets you have will be collateral. And again, if your business falls, the bank can run after all of these collateral that you put up. You can't also split profits and losses with your family members. So if you're losing a lot of money, you can't say, oh, can you share with me, and you lose some of it and you lose some of it, or maybe even use this for tax purposes. Only you, as a sole trader, can use it for tax purposes. So in other words, whatever expenses that you have in your company, you can use it to reduce your net income, which also reduces your taxes. You're personally liable for taxes on income. So the government can run after you personally if you declared so much money in your business and you haven't paid the taxes. The government will run after you, not the company. So partnerships are quite similar to sole traders, except that, of course, you have divided the risk between you and another person or persons. Okay, so partnerships can be up to 10 people partnering in one business. But once you have that partnership, each partner is equally responsible and liable for debts and obligations. There is such a thing as a limited partnership, and that is the liability. If you form this kind of an arrangement and you register yourself as a limited partnership, by the way, this is what you might see some companies called PTY Ltd or PL, proprietary limited. Have you ever heard that term be affixed to a company?
Yes, sir.
Yeah, that means it's usually a limited partnership, which means liability is limited to the amount of money you have contributed to the partnership. So if you have invested $100,000 in the business and the business folds up, then technically the government can run after up to 100,000 because that's how much money you have put in the business. If that is gone, then there's no more liability. Incorporated limited partnerships, limited liability for the debts of the business. One or more general partners, however, will have some unlimited liability. So if you do an ILP, there has to be at least one partner who will have unlimited liability in case the company has debts or it folds and becomes bankrupt. So in other words, if I might create a company, a limited partnership company, I am one of the owners, and then I'm attracting an investor. The investor comes, okay, it's a good business, but I'm scared that if the business collapses, they may run after my money, my own personal assets. So you might reassure the investor and you tell the investor, don't worry, it's a limited partnership, an incorporated limited partnership, which means you're only liable up to the amount of money that you have put into the company. If there are bigger debts, then they will run after me and not you as the investor. Okay, so that's what we mean by a limited, incorporated limited partnership. So these are some of the advantages. With partnerships, you will need to pay GST if your business is selling more than 75,000 Australian dollars every year. Okay, so disadvantage, of course, is there's always going to be an unlimited liability somewhere if it's a partnership. You can create a company, and in the US they would call this a corporation. Okay, but for here we just call it a company. And once you do that, then it becomes a separate legal entity. And what that means is, if the company folds up, then debtors, not debtors, but the creditors can run after only the company's assets and not the assets of the owners, because it is a separate legal entity. Members are not liable for company debts. So members meaning employees and stakeholders and shareholders. So the pros, meaning the advantages, are such. So it's controlled by directors and owned by shareholders. Company members have limited liability. Money earned belongs to the company, doesn't belong to a particular person. And it means wider access to capital. In other words, you can sell shares, people can invest in your company without very much regulation. And by the way, because of that, you have better exit options. You can sell your shares. So if you don't no longer want to be part of that business, you can grab your shares and sell it. You remember the video of that girl who owned the coffee shop in London? So
Yes.
you remember she sold her business. So obviously it was a company and she sold her shares at the end of the day. She made some money out of that. She's no longer part of that company. But again, it's easier because there's a value to the share. And sometimes if it's a listed company, then you can actually sell your shares on the stock market. It's more complex. I mean, that's a disadvantage. It's more expensive to register. Every year you need to pay. Must comply with the Corporations Act. Every year you have to do a tax return to the ATO. You need to have a review. You need to pay. So it's a financial review has to be done every year, and you need to pay every time you register that statement, financial statement. There are other forms of partnerships and corporations. Now, I wouldn't say these are necessarily legal forms, but they're just a way to sort of identify your company as something different. So a B Corp, B Corp actually is a certification. So if you're a company and your main role in your business is to solve social and environmental problems, so it's a very altruistic venture. You're not there necessarily to make money, although you can make money, but your main mission is to help other people or help society, then you can apply for a certification to become a B corporation. What do you mean by B? Why B? Make a guess, anyone? You still with me?
Yes, but have no idea.
So B stands for benefit. That's why it's called a B Corp, because you're there to help society. So it's almost like a charitable business. So except that you can be a for-profit but still be a B Corp, they call it. So another form of a B Corp is a low profit, a limited liability company that facilitates investments in socially beneficial or for-profit ventures. So in other words, you're facilitating investments, but the companies that you invest in are socially beneficial. They help other people. They help poor communities, for example. An example of this might be Thank You Water. I don't know if you've heard of that. Thank You Water established, and all their profits actually go to creating water sources for poor communities around the world. You buy a water bottle from 7-Eleven that says Thank You Water. Part of that, the proceeds of that, go to helping people gain more water for their communities.